and take it away.
Welcome, everybody. Thank you, Drew, so much for inviting me to be here today. I'm gonna switch my screen over here to share as I get set up here to share the deck. I am, as always, really privileged to be able to talk to the AMI audience, and we have gotten such good and inspiring questions about agencies and how they use AI. And it's been very helpful to me in sort of formulating not only the content, but in getting ready for what your peers might want to ask in the future. So let me just get ready to start my show here. What am I doing wrong?
Well, we see your screen. I mean, I know.
Start the slideshow. I'm not seeing the buttons up here to start my show. Oh, I know why.
There's this new thing, this Zoom thing. It's kind of a crazy new technology.
Yeah. Yes. And this is why I went to law school. So I would not have to understand technology and how to work it.
And look at you now, what you're doing.
Yes. I understand the legal implications of the technology, but I need a tech guy or girl to work it for me. All right. Anyway, thank you all for hanging in there, for being here today. If we haven't met, I'm Sharon Toerek. I am founder of Toerek Law, and we do business in the agency world as legal and creative. And we help agencies protect their assets, monetize their work in 3 areas: intellectual property, development and negotiation of strong contracts, and marketing regulation compliance. And what we're going to focus on today is not the technology and the tools, obviously, behind AI, or GAI, as we now call it when we're referring to generative AI, which is what's creating all the legal issues potentially for you and your agency. But we're going to talk about the legal implications of adopting it in your agencies, offering deliverables that you've used generative AI to help you create to your clients. And I like to always give everybody a roadmap as we get started with the conversation. I'm going to give you a very high level and quick overview of the types of intellectual property protection for generative AI created work, because this is an area where we get a ton of questions. And so just some concepts for you to be thinking about, and what the current state of play is from both a copyright law perspective and otherwise. Then we're going to talk about what I perceive right now, as we're talking in August of 2023, to be the fundamental business IP issues that relate to generative AI. It's nice to sort of have that scholarly overview, but when the rubber hits the road, what are the things that are really causing the conversations or causing the heartburn for agency owners as they think about how to implement this? And then some practical legal steps that you can think about taking in your agency to protect yourselves and limit risk and liability associated with using generative AI or work deliverables created using generative AI. Okay. So let's talk a little bit first about the types of IP protection for works that are used that are generated from an AI platform or technology. Initially, let's talk about copyright, because this is typically the area where we see the most questions right now. Most of you, I think, have a fundamental understanding by this point, because you've been reading, you've been talking to other folks in your industry, to understand that as far as the Copyright Office in the United States is concerned, the only works that are entitled to copyright protection via copyright registration need to be human created. So works that are created using generative AI cannot be registered with the Copyright Office. They cannot be, therefore it's going to be impossible for folks to pursue copyright infringement lawsuits based on the work as a whole, because they can't get that registration that entitles you to do so. And so what does that mean, really? What about, and a lot of the questions I get are, well, what about work that is partially created using AI and that we then edit or punch up or polish? And what about the argument that generative AI is just like a camera or a piece of software or some other tool that enables our creative team to make the work. Well, how is this any different? I don't have a great answer for you for that last question. All I can tell you is that as far as the Copyright Office is concerned right now, it is. Do I anticipate that viewpoints on this might evolve over time? It's definitely possible, but it's going to take a lot more case law and or intervention via legislative maneuvers in order for that to happen. In the meanwhile, what we're led with is the possibility that any work that you create and want to deliver to a client that is half and half or part and part is not in its totality able to be registered with the Copyright Office or for copyright to be owned in it. Does that mean you don't own any of it? Not necessarily. So let's talk about Zarya of the Dawn, a graphic novel created by the artist Christina Kashtanova. I love that name. And I also think that this character looks like Zendaya. I don't know if any of you see that, but I certainly see it. She created a graphic novel that she wrote the copy to and used Midjourney to create the illustrations from. And she was very transparent about the fact that Midjourney was used as the source of the visual elements of the work. And she applied for and actually did receive a US copyright registration for the entire work. Once the Copyright Office got wind of the fact, and I'm not entirely sure how they found this out, how it was brought to their attention, that the illustrations had been generated by AI, the Copyright Office canceled her registration. So she then appealed that and argued that, just as we were discussing a moment ago, this was a tool that we used. And not only that, but the curation of the work as a whole, I'm the one who decided, me, the human, decided how to lay these images out. I wrote the text. The overall theme of the work is mine. And so what ended up happening is that she was granted a partial registration in the copy that's in the work and in the arrangement of the imagery, but not the images themselves. So it was sort of a split the baby decision. And it's an example of how the Copyright Office is looking at right now these arguments that there can be works generated that are part and part, and that there is still some original human insight and originality in works many times, even if AI is used to generate a component of them. So that's where we stand right now.
So Sharon, on this,
yeah,
she owns as much of the copyright as can be
owned. Exactly right. There's the maximum amount of copyright ownership that can be owned.
There's still value in pursuing these things as opposed to leaving them unprotected, right?
Absolutely. And remember that you may have different priorities as an agency owner, or your client may have different priorities about protection versus ownership of these works. Right? As we all know, intellectual property ownership and the transfer of that ownership are always a component of the relationship. Ideally, they're a conversation you have that's reflected in your contract with the client. So this is no different. As you point out, Drew, it is a question of, first of all, is it ownable by anybody? And second of all, to the extent it's ownable, who might own it? And that is as much a conversation between your agency and its clients as it is a function of what the terms and conditions of the platform that you're using might be. And we'll talk about that in a moment. But this is the best example we have right now of how to sort of split the baby on this. And a question I get a lot, and I'm happy to talk about it more during Q&A, but how much change can we make to something that gets generated out of AI and to ultimately end up owning it? Is there an amount? My answer to you is no. Unfortunately, there is not.
No defined amount.
Not a defined amount. And there's no litmus test, yes, for determining how much human intervention is added to an AI created work for it to be yours or ownable by anybody. So I think this is going to get crisped up as time goes on and as more test cases in the form of filings or litigation get brought. And Congress is showing more interest in legislating AI than they have in a lot of the other, technology issues that face marketers. For example, data privacy. We still don't have a federal standard on data privacy. However, they're mostly focused on it from a cybersecurity perspective and making certain that AI is safe from a national safety point of view than they are with the ownership of the works that are created. All of the economies of all this are interesting to them too.
So in the past, agency owners, you've always advised them to, in their agreements with clients, to acknowledge that the ownership of the work and the copyright of the work get transferred to the client when the work is done and the agency has been paid.
Right. And we don't, we haven't changed that advice. That's still, that is still good advice. Unless, there are exceptions to that. For example, you want to keep the work and you want to license it to the client. But yeah, that advice hasn't changed, and you want to still be managing IP conversations that way. That said, and we're going to talk a little bit at the end more about this, but there are opportunities to punch up your master service agreements or your professional service agreements to specifically address AI generated work and deliverables. And this is one of the things you'd want to discuss in that section of your agreement. Just as you would discuss ownership and licensure of stock photography or videography or any other third-party created work.
Okay.
The patent office has the same view so far as the copyright office. To be patented, not only does your invention have to be novel, original, but it requires human creation. So do I think this will evolve as AI gets smarter and it's writing code and concepting products? I do, but we're not there yet. We're not there today. Trademarks. This is a good time to remind everybody that a trademark can be something that is also subject to copyright protection. What do I mean by that? If you're creating an identity for your client or branding one of its products or services, there's the name component of that, the word component, the literal element as it's known in the trademark world. And then there's the visual component, for example, a logo or stylized treatment or a particular font or a choice of layout. So the former, the word only stuff, there's no copyright implications there. The latter, you're creating design that could infringe upon somebody else's copyright potentially. And so what's the state of play right now with respect to trademarks? The biggest thing I think you need to be concerned about as an agency is understanding that using AI to generate inspiration or drafts of potential brand identity elements is that it's not so much the copyright duplication that is likely to be your number one problem, although it is a possibility. You can definitely infringe on somebody's copyright if you take a design that's generated on AI and turn it into a trademark. It's that layered on top of your normal trademark due diligence, which can't be avoided just because you generate the trademark or the logo out of AI. So for now, you've got to continue to do your normal due diligence, run your trademark searches, get your trademark counsel to do that for you, interpret the results. Trademark rights are based on use in commerce. They are based on whether or not they identify some product or some service that's being sold by some party in commerce, not on originality and not on how close they are to another design. And so that hasn't changed, and you've got to not slack on your due diligence with respect to trademark. Don't assume that the AI generators have done any of this work or this screening for you, because they are just spitting out whatever training data has been fed into them. So do your research before you implement any identity, any trademarks, logos, brand marks, whatever that you used AI to generate. Trade secrets is, I think, something that there's a couple of implications here that I want you to be aware of as agencies. Remember that the generative platforms themselves have trade secret protection in their data sets. So The only way you're ever going to know whether something's been fed into an AI tool is if you end up having today, is if you have to sue that AI tool's owner because of some infringement or issue or contract violation or whatever it might be, and have to go through the discovery process. Other than that, it's their trade secrets, what they've fed into their engine and how they're using it to train their large language models to get smarter and smarter. So remember that they've got trade secrets and this massive warehouse of data that they're storing, even though it was fed in by other people who may not have owned it in the first place. So just keep that in mind when you're interpreting results. Prompt engineering, and I think this is a huge opportunity for agencies potentially. There's a certain amount of trade secret protectability, I think, potentially in how you develop your frameworks for developing prompts. So if you've got a particular way you analyze a problem to determine how you script your prompt to put into AI, I think that process, I think that that framework or that mechanism is potentially protectable to your agency as a trade secret. So you have to have the conversation with your client about whether you're going to let them know about your strategies or your framework or keep that internal. But I think there's a big opportunity here in an industry as creative as the agency world. You all have lots of experience with proprietary frameworks, proprietary processes, and I have no doubt that many of you are already translating that into your own frameworks about how you, developed your prompting strategies. In the beginning, we're all going to be hunting and pecking, right? We're going to be throwing searches into GPT and seeing what comes out. But as we get more sophisticated and experienced in using these tools, there's going to be a method to how we develop our prompts. And I think there's some trade secret opportunities there for you and your agency. So I want to raise it as a potential red flag, but also as a potential opportunity, as is much of AI for you all. It's really a balance between risk and opportunity. All right, so what are the two fundamental business IP issues that are most invoked or most come to the top of everybody's thoughts when you're thinking about using generative AI in your agency work? First of all, protecting the inputs into the generative AI tools. What happens? What are the implications of using human created and owned work to train the GAI models? For example, what about data that your client may have given to you that could be proprietary? What's the implication of somebody on your team feeding that data into a generative AI tool in the form of a prompt? What about mentioning product ideas? What about mentioning marketing strategy ideas? Any of it, all this is potentially prompt worthy, if you will. And so you've got to be careful as an agency about what you are feeding into the generative AI tools that came from your client. You've got to have some transparency with your client about that. You've got to be careful about what you're feeding it and what you're telling the generative AI tool, because you can't unring that bell. Once it's fed in, and it's really, it loses its trade secret protection when it's not a secret anymore. So you got to be dialed in with your client about that. And then who's liable for misusing the input intellectual property? Let's say somebody has fed in a script for a commercial or logo or artwork that is then generated out when somebody does a prompt to look for a potential logo inspiration. Whose fault is it? Whose liability is it if there's an infringement that occurs? I can tell you that as between you and your clients, they're going to want you to be holding the bag about that. So you've got to be careful about that in your agreements and come to an understanding about whose responsibility it is and what the level of transparency there is going to be with your client. What if the output gets implemented in the marketplace in the form of a new trademark or an advertising copy or a commercial script that resembles something else that got fed into the generative AI engine. We've already talked about you and your client. What about you and the company that owns the AI platform? Most of the terms and conditions you will see on these platforms will point the finger your way. So yes, you can own it, user, subscriber, member, whatever you are, but we're not going to be responsible for any infringing you do or any damage that you cause as a result of putting the output out into the world. So it's a bit of a double-edged sword. So you're going to be thinking about you vis-a-vis the client and you vis-a-vis the AI platform owners. And we've already talked about the prompt strategy itself and the potential ownability of it. So the best example of current legal action that I can bring to your attention right now regarding responsibility for protecting work that gets put into the AI platform is existing litigation right now filed against OpenAI, which, as we know, creates ChatGPT. So there's a number of prominent authors and the comedian Sarah Silverman who have sued OpenAI because their novels, their books, their scripts, their work have all been fed into OpenAI and can be used in the solutions that are generated by a prompt. And so their argument is you're profiting off of our intellectual property and you don't have our permission to feed this work. You didn't have our permission to feed it into, remember, it's a bell you can't unring. It's in there now, but you didn't have our permission to do it. And we own the copyright in this stuff. And therefore it's our right to decide how to use it. So it's early days. This was just filed in early summer. We don't know which way it's going to go. And, there's an argument. I was just having this conversation with somebody at the MAII conference. There's an argument that the work that got fed in was already derivative. So how strong could the case be? I don't know the answer to that, but if I'm a creator of an original work and it's fed into OpenAI without my consent, and then someone sees it in the output of OpenAI and implements it somehow, I should be compensated under the current intellectual property laws that we have in the United States. And so how are we going to resolve that when it's so easy for somebody to just take my work and put it in the machine? And if I can even discover that it's been used on the other end of things, what's my positioning there? What should I do? And what are my rights? So we've talked about protecting the input. Let's talk about owning the output. Can you protect the output of generative AI tools? I think we've discussed that you can in part, especially if you've added human created content to it. What about the machine created portion of it? You can probably own it. Can you protect it? That's an open question that nobody knows the answer to right now until we get a little bit more clarity from the regulatory bodies who run the Copyright Office, as well as the courts as they start to work their way through some of these cases. So as far as the platforms are concerned, you can own it. As far as your client is concerned, maybe they think they own it. But how protectable is it? Right now, not very. So just your mileage may vary, just know that. And proceed with caution and with a lot of transparency with your client, which we're going to talk about specifically in a minute. And then we've talked about the question I get a lot, which is, does it change the things? If we've added to it, if we've changed it, if we've created a derivative of it, if the end product looks very different from the underlying thing. These are all still open questions that we have to keep our eyes open for. All right. So 5 practical legal steps I want to leave you with to actually bring some of this into your daily business practices, because it's great to have the high level knowledge, but what does it mean to you when you're running your business? So let's talk about a few things you need to think about doing from my perspective right now to legally put yourself in a strong position as an agency. First of all, the conversations. Be talking with your clients about their use of artificial intelligence. Is any of the information or data or research they're giving to you AI generated? Do they have a firm policy about your use of AI tools to create work for them? Is there a limitation on which tools you're allowed to use? What purposes you're allowed to use them for? Have these conversations with your clients. And ultimately, the expectations need to be probably translated into your statement of work or your master service agreement in some way. Talk to your content collaborators and your vendors. I know just about all of you work with freelancers. You also work with other agencies, production firms, video firms, others who create work, audio, visual, print only. You need to be talking with all these people about their AI practices. Are they using AI? What tools are they using? What parameters do you need to give them based on what your client has said to you about using AI? What are your disclosure requirements when they hand you the deliverables over? Do they need to be telling you where they got them from or what they used to get them? With your employees, we'll talk a bit about policy making in a minute, but this is, most of you are doing a really stellar job of getting as much information to your employees as you can right now about it, particularly if you're an AMI member. You all tend to be very proactive about education. And so have conversations frequently and openly with your creative team, especially, and about the work creation, and with your account team about the questions they should be asking the clients so that there's a common understanding about use of AI to create the final work product. All right, speaking of policies and procedures, we've talked about a few of them, but what tools are approved and what is the approval process if someone wants to start using a new tool? What level of leadership does that need to be cleared through? Does it need to go to a creative director? Is there someone else on point in your agency who should be approving that? Think that through and decide how that should result in terms of the policy. What are the use cases that are okay for adopting generative AI for? Can you just use it for inspiration? Can it be used to create first drafts? What about research? What about strategy? And then what are the human stopping points? What are the checkpoints on any of the work before it turns into a final deliverable to make sure that it meets quality standards, that accuracy of facts have been verified, that in the case of a trademark, that no other trademarks are infringed. So what are the human checkpoints before this work gets out of your agency's door at the end of the day? All right, we've talked about internal policies as well as external policies. So some of these are internal, some of them are external, but what questions are we going to ask our vendors, our contractors, or our clients? I know I mentioned it already, but what specifically do you want or need to know? Write it down, create a checklist, make it a dynamic document so that it's part of your policy and part of your onboarding practice with your clients ongoing if you're going to be using AI on a routine basis. Who approves what data gets put by the agency into any GAI tool? Just like we mentioned before about that human checkpoint before work gets out the door, who is the final arbiter in your agency of what work gets fed into generative AI? Your clients provided you with specs, with requests, with market research, you name it. There's a treasure trove of information that you get as an agency before you ever start doing your own work. So who decides what goes into generative AI and what conversations have to occur with the client before that happens? And then what's your risk tolerance? You need to really think about this. Agencies as a community tend to be a little more tolerant of risk than other businesses of your size and scope, but that's not true of all of you. So be thinking about what your risk tolerance is. Take a careful look at your insurance policies. They're unlikely to address AI specifically at this point, but you need to know how much coverage you have in case something goes sideways. Review the terms and the conditions of any GAI tools you use. If you're using ChatGPT, read the terms and conditions so that you understand what you own and where your liabilities are. Same for Midjourney, same for Bard, same for any of these tools. trust me, they have well and hard thought through the things they need to do to indemnify themselves. They're not interested in covering your backs as an agency that uses this as a tool to run its business and create work. So that's on you to do. And then familiarize yourself with what their position is on who owns the output. I will tell you, generally, most of them take the position that you own it, but you also own the risk associated with using it. They're fine having you own the output because if you think about it logically, they didn't own the inputs to begin with, right? Someone fed that into their training data. All right, let's talk about your contracts as an agency. You should all be thinking about addressing generative AI, and we're going to talk about some ways that you can do that in a moment. But what are the types of things you need to be thinking about, including in your contracts? First on the list, limiting liability, right? This is another way of being transparent with your client, is by presenting an agreement with them or by putting language in their agreement that holds you harmless for the output, subject to whatever guardrails you both agree to put up. Likewise, just like you should have language in your master service agreement related to owning of the final work that's created, and the triggers for the transfer of the ownership. Spoiler alert, it shouldn't transfer until you're paid, but if you know me, you know I was going to say that. So same thing for deliverables that are created using AI, except that you've got to have the client acknowledge in the agreement that anything that came from AI is subject to any third-party rights in the underlying work. I'm not saying that's going to be an easy conversation to have, but it is the law of the land right now. And if you're going to be transparent about using AI, you've got to be transparent about the risk with your clients. Do you disclose the specific tools that you're going to use? I'd say this is less likely an issue for the MSA and probably more likely an issue for your statement of work or statements of work. It's an open question though, if you put it in one document versus the other. It should go in writing somewhere though, so everybody understands and is informed. And so your client can't come back later and say, we didn't know you were doing that. Well, you did, because here it is in our statement of work that you signed off on. Approval criteria. This is even more important than normally it is. We always advise approval criteria in any master service agreement. For example, if you do branding for your client, you, client, are responsible for trademark searching and trademark protection and approval before this hits the market, not us. Or you have to have your legal department review the ad copy we created before it gets released. That's not our responsibility. Same thing for AI created work. Address it specifically because you've got all these potential third-party rights that are at play when you've used AI to do work. All right, and then we've already talked about this, but this is a definite step that needs to be factored in to your policies and your procedures. And more about that in a second, but as a policy, you want to make certain your team understands that they should be avoiding putting any client, business, or confidential information or any agency confidential or proprietary information into a GAI tool without the permission of fill in the blank, whoever needs to approve this at your agency. All right, I'm going to take a breath here and point you to a few things before we open it up for questions. And I hope you came loaded with a lot of questions because this is a fascinating and fast-moving area. This is a link to our AI Resource Center for AMI, so feel free to go there. You're going to see a couple things there. You're going to see a conversation checklist. You're going to see an invitation to an upcoming Q&A session that our firm is doing for agencies on AI later this month. And I'll tell you how to register for that if you're interested. And I hope you do come. We've got quite a few people coming already, but we're going to be leaving the mics open a really long time for questions. And you're going to see information about how to get on the waiting list for an AI resource we are creating right now for agencies, which is going to include the contract language, the policies, and some of the other things you need to be thinking about for your legal compliance journey when you're using AI. But there's a ton of free stuff there as well. So I'm going to pause there and I would love to start answering some questions hopefully some of you came with them.
All right. Well, you guys will get this deck. So Sharon, if you stop sharing, then we can see faces if they want to pop
Sure.
on video. So if you guys have questions, either ask them in the chat and I'll read them, or unmute yourself and then ask. And if you want to change to video so we can see you, that's fine. If not, that's okay too.
Don't be shy.
Stunned silence.
Yeah. You know, and I don't, this can be a lot as an agency. You can kind of start to think about, why should we use this at all?
Yep.
I don't think you're going to be able to avoid that long term. I think you're going to have strategic advantages if you understand how to adopt this smartly. And I know you all are having those conversations with your peers. It's just my job to help you understand what the potential risks are, and all you can do is be as prepared for them as possible.
Yep.
And
all right, so I've got a question. Should we update master service agreements with current clients now, or when we go to sign a new one? Like, should we go back and say we've changed this, so we need a new signature, or wait till renewal time?
I would say for the clients with whom you are already under contract, if it's going to be a while before you're in a position to renew your agreement with them, I would take the version of your external AI policy that you should be creating and have them sign off on it. Actually, you know, turn it sort of into an addendum or a term sheet to the MSA. You can reference the MSA in it and then present that to them and say, look, AI wasn't a factor when we started working together the way it is right now. And so we've had conversations about using it together, and this is our policy, and we'd like you to acknowledge it. For the clients who you might be in the process of renewing agreements, or you're going to be doing it soon, then you want to have some AI language to address those issues right in your MSA, which is one of the things that the toolkit is going to help with.
So it was touched on in the discussion of copyright and trademark, but specifically, what are your thoughts on using GAI in logo design?
I feel about GAI and logo design the way I feel about agencies that rely heavily on some of these logo inspiration websites. I think that it can be relatively low risk to do it for inspiration if you couple it with a full trademark due diligence. And by that, I mean run a full trademark search, make sure nobody's using something confusingly similar to it in the category that your client is in. So that's kind of the way I feel about it right now, is that, you know, your client's primary concern is more likely to be infringing another person's trademark in that situation than another person's copyright. So I kind of feel like you need to use the same degree of caution you would use if you're going to use an inspiration website. Do your trademark due diligence. And, you know, I'm still a fan of originality, but I recognize that inspiration is a big part of brand creation. So hope that helps.
Okay, so somebody just asked another question about using different, like Dribble or whatever, but it sounds like you that was part of your answer.
Yeah.
All right, other questions?
This is Dave. Can I just ask this instead of typing it, because I don't know?
Yes.
Okay. So
You're
the
very
question
old
is,
school, Dave. I like it.
would there be a threshold or a proportionality of AI generated output, whether it's content or a design, where someone might get the concept, but then hand it over to the designers or the content team and go from there, where it would be considered ownable and mostly organic at that point? Because I'm getting the sense that anytime it's touched by, or the output is generated by a tool, from that point forward, it's you know, non-copyrightable or ownable. So I wonder, is there a threshold, and would there ever be a tool set to use to determine that? Could somebody say, oh my gosh, we we see elements of, Midjourney or Jasper or something in there, and you guys cheated.
I think that there will come a time when the rules on this change a little bit, but there's no threshold today. There's no guidance on how much do we need to change or polish or contribute to something that was generated by AI in order for it to be considered our original work or ownable by us or our clients. So the best advice I can give in that situation is that think about the copyright infringement legal considerations, and I'll just go through a couple of those with you. Would the finished work interfere with the market for the original work that you might be infringing on or duplicating? The answer is no. Your risk is lower. It's not nothing, but it's much lower. Would the risk change if you are transforming? It's a concept called transformative use. If you're using the output for a completely different reason than was the goal of the original work that got fed into AI. What's an example of that? Someone fed some literature, like an entire novel, into generative AI, and some of the quotes or some of the parts of that novel show up as a result of the prompt that you engineer. Could you use that in ad copy? Maybe. I'd say that's mid-risk, right? Beyond that, there aren't any guidelines yet. I'd love to have some. I'd love the Copyright Office to say, or for some case law to say, if you've taken less than this percentage of work from AI and the rest is human generated, then it can be owned by a human, etc. We just don't have that guidance yet. So I hope I've given you a couple of examples of where your risk might be lower or midline. Where your risk would be high would be writing a commercial and getting part of the script out of generative AI, and it turned out to be part of somebody's novel or somebody else's script or a song lyric or something like that. That would be a high risk.
Thank you very much.
Yeah, I hope that helps.
Hey, Sharon, I have a question. I need to do some more research, but my question is about the difference between Midjourney and Photoshop, their new beta AI. Midjourney is fed information. Photoshop is really just fed prompts. So I don't know if it's getting its inspiration from other artists' work or just from data. But are there any right now, is there any legal risk with using Photoshop beta for, like, example, content or content-aware fill, auto-generated fill, right? So you select, say someone's laying in a field of grass, you select around the person, you fill that field with flowers versus grass. That's not fed into anything I feel is right now open source. I feel like it's protected by Adobe. So is Photoshop, does Photoshop put you at the same risk as Midjourney? Because Midjourney is a wild card, I know for sure, but what about Photoshop and this proprietary technology?
My concern about Photoshop, and I have to admit, I don't know a lot about the tool technically, but my concern, because of it being an Adobe product, is that they are feeding in stock images to which somebody owns the rights, and that therefore they're creating a farm system for copyright cease and desist. Whether that's their intention or not, I'm not suggesting that one way or another, but that's definitely a revenue stream for Getty and Shutterstock and the likes. And so because of Adobe's business model overall, I would be concerned about the scenario you described and the usability of that. Whether or not it's a copyright infringement would depend upon how different the final looked from the original, I suppose, but there is some direct copying going on there. So I still think there's a mid to high amount of risk in that scenario.
Yeah, because the grass to flowers is a real basic example, and I totally understand that. But you can actually, if you take it like 100 levels deep, yeah, you just keep tweaking in certain areas of the background. There is no way humanly possible to interpret what's been manipulated, what's not, what's custom. So I guess at a certain point it becomes yours, and that's the whole thing you talked about earlier.
Yeah.
So
Yeah, your risk reduces at some point. We just don't know
yeah.
at what point.
Okay, thank you.
Yeah, great question.
Other questions, either in the chat or just unmute and
I'd
ask.
actually love to hear some anecdotes if anybody's had experience with implementing AI generated work and either had to have a challenging client conversation or had to have a vendor conversation, or had their own internal heartburn about, IP and copyright, and doesn't mind sharing. Consider me a big AI generator. I'm taking your input and using it to inform my advice to your colleagues. I'd love to hear about real world examples of when this is coming up for all of you.
Or even questions your clients are asking, or the kind of
Yeah.
conversations you're having with clients. I just think this is like the no man's land right now. Everyone is just it's like the wild, wild west.
And I'd also like to know, is this something your clients are bringing up with you at all? Or
Right.
are you, and if they're not, are you prompting the conversation with them? So if anybody could speak to that issue, that would be really interesting. Hey, Scott.
Hey, Sharon, we've kind of started the early stages of our policy, but we're not using it for any final content. We're using it for research, feeding it non-proprietary things, using it to get prompts for good questions if we're going to interview an expert, writing a very technical blog for a client or something like that. But I mean, we've really challenged our team, one, to keep anything proprietary out of it, obviously. But the other side of it is we've got a policy we're about to release that we actually use ChatGPT to help write the AI policy.
Yeah.
And it actually did a pretty good job on it. And then we bounced it off our counsel and everything. And it's more just how we use it and how we don't use it.
Yeah.
And we felt like as an agency, our job is to be very open with our clients of how we're using it and how we're not using it, that we're not just feeding final content into it or getting it to spit out stuff so we can be lazy about doing good work for them, but
Right.
we are using it to produce better work for them.
I think you make a really good point about the difference there's a difference between probably technical liability and then actual risk assumption based on the end audience for whatever it is you're creating. If you are creating something for an internal audience, a policy manual, a business plan, something that's going to be for internal use only, that's not going to be exposed to the rest of the world, I think your risk ratchets down significantly. So I'm a big fan of using this and getting training wheels off by practicing using it for your internal materials, because your audience is more discreet and you're not putting it out into the world or putting any client at potential risk for it. So I love that example. And I think that's a perfectly great starting ground for using this. So thanks for contributing that. And are your clients asking you at all about this, about whether or not you're using AI and how you're using it?
It's coming up in casual conversation, but surprisingly enough, we're not getting a lot of those questions of, hey, tell us how you're using it or using it for our work. So, we've been more offering how we're using it, everything from, like I say, research to we've played with an AI video avatar, actually creating an avatar we can feed scripts to, and shot it in front of a green screen in our studio and trying to figure out use cases where we could sell that to a client,
Yeah. I can tell you my perspective based on, I was just at the MAIA conference and quite a few corporate marketers there. Agencies are ahead of the curve in terms of thinking about this and what their legal risks might be. Most of your colleagues in-house in marketing departments, their risk management people might be starting to think about it from a cybersecurity or trade secret protection point of view. But most of the marketing teams in your client organizations are behind you in terms of proactivity. from what I can see so far. I'm sure there's examples of where I'd be wrong there, but that's kind of the general arc. So use that advantage to position yourself as leader, your clients, and as knowledge bearers to your clients, because you're gonna look so much more helpful to them than you already do as a creative partner to them.
Yeah, Christine made the comment, and I do think this is important. She said, we've got to get a policy in place because everybody inside the shop is sort of using it their own way, and we don't really have a defined way to use it. And I think that may be the place for all of you to start if you have not started, is first figure out what your agency's guardrails, attitude, beliefs, practices are. And I put out something, I can't remember if it was a video or if it was a blog post, but what a lot of agencies are doing is they're creating like a think tank or a task force, a mixed task force of the agency's sort of skill sets. And they're experimenting with different things. And they're bringing them back, the tools back to the agency at large and saying, hey, for 2 weeks, we played with this tool and here's what it does and whatever. And then talking about each tool and sort of making some rules around it. So it really does have to be experimental because it's all changing so quickly for sure.
And dynamic, exactly. You got to be willing to change up the policy as the AI tools get more intelligent.
Yeah.
And got to be willing to ratchet up the conversations with your client and be the leader here, not wait for them to ask you about it or mention it.
Right.
Because the time span you have for not being proactive about discussing this is, I think, getting shorter and shorter. So,
So Brad saying in the chat, we wrote and distributed a written statement on GAI to all of our clients about 90 days ago. None of us have questioned us, but several thanked us saying no one had been proactive in reaching out on the topic.
I love it. Yeah, that's awesome. Yeah.
There is opportunity for you guys once again to show your clients that one of the reasons why they are in partnership with you is because you are out ahead of the curve thinking about these things. So it is an opportunity for sure.
Yeah, I love it. That's how you become a partner to your clients, not just, a creative vendor or a strategic vendor. If you go to the resource center, you will get on the early notice list for some things we're going to be releasing to help with that as well, if any of you are interested. But I think that leading the conversation is going to be such that, and leading the charge in terms of how you design and engineer your prompting strategies. I think those are two huge opportunities for agencies right now, because who does that better than an agency? Thinks about what the framework is for how to solve a problem or create an opportunity for your clients. Agencies are awesome at that. So I think that's a huge opportunity, which is why I think of AI for agencies right now as a balance of risk and opportunity. There's plenty on both sides of the seesaw.
Yeah.
Perspective. Yeah.
All right. Any other questions? We're almost at the top of the hour. Sharon, as always, thank you for being our go-to resource on all of this stuff. I'm always super grateful at how generous you are with your time and your expertise, but I just am really glad that we have you to come to and ask these questions. So thank you.
Well, it's the pleasure is mine. I'm grateful for all you do for agencies as well. And if any of you have questions, don't feel shy about reaching out offline. Be happy to be helpful as I can. And I hope to see some of you on the 24th, because if you haven't thought of a question today, there'll be another forum there for you to ask.
Yep.
So thanks so much, everyone, for joining us today. Thank you, Drew, putting this together and for having me here.
Yep. Happy to do it. All right, guys. Thank you very much. Watch for an email from me, the member only email with links. I'll get Sharon's deck, the video, and her contact information. Okay. Always good to see you guys. Thank you.
Bye all. Thanks.
Bye.